Good evening everyone, my name is Dalit Soni and you are watching Drishti IAS. In this session, we'll be discussing about the developments which has happened with respect to polity in the last week. So I welcome you all in this new episode of Polity this week, and we'll be discussing 4 or 5 topics today. So let's start. These topics can be important for your examinations point of view. So we'll be discussing the Enemy Property Act 1968. We are discussing this particular topic because recently you must have heard that the property of you can say ancestral property of Pervez Musharraf actually was there in UP, and that will be auctioned now. Okay, in that regard, this particular topic, that is the Enemy Property Act 1968, was in news. So we will try to understand that what this act is. Okay, second, we'll be talking about the constitutional amendment in India. When we talk about the procedure of the constitutional amendment, okay, so we'll be talking about that. Why? Because you must have heard that opposition saying again and again that this current government will try to change the constitution, etc., etc. So these discourses are there, whether it is easy to change the constitution like that. So we'll be discussing that, what is the procedure of constitutional changes and the amendments in India. Then Election Commission of India, will be talking about this particular topic because you know that Haryana, or you can say Election Commission, has changed the dates of elections in Haryana, state assembly elections in Haryana. Other than that, if we are talking about the, you can say, Jammu and Kashmir Union Territory, there will be, you can say, assembly elections over there. So that is why it was in news. Then GST Council, recently there was a meeting of GST Council and they have actually shared some development over here. They have created group of ministers for certain changes in that or certain reforms in that. So that is why we will be discussing GST Council as well as, and in the last we will be discussing the doctrine of amphibious operations. Now from this particular topic, only one thing which is important for you is that what is amphibious operation. We will be discussing that. With that we will also discuss CDS, because CDS has actually you can say came up with a new document of this doctrine of amphibious operations. So we will be talking about these 4 or 5 topics today. So let's start with the first one, which is basically the Enemy Property Act. So before moving further, I would like to take this opportunity to announce that on the occasion of Hindi Divas, Drishti IAS has brought you a special discount, that is flat 40% discount on all our online courses, pen drive courses, test series and DLPs. And for those who are preparing for the PCS examination, for these courses, that is UPSC, RAS and MPPCS GS Foundation courses, there will be a discount of flat 40%. And to avail this offer, you can directly click on the link which is given in the description, or you can call on these numbers that is there, 8010440440 or 87501 Okay, with that we'll be moving forward. 1968. Okay, as I told you, it was in news because of the, you can say, former president of you can say Pakistan, that is Pervez Musharraf. His ancestral land was there in UP, and recently it was decided that that land might be auctioned. Okay, so we'll be seeing that what will happen if there is you can say property of a person who has migrated to Pakistan. What will happen to that particular property? Now there is this term, that is enemy property. There are certain countries with which we do not have very cordial relations, so we term that countries as enemy countries, or you can say when we talk about the properties which are attached to a person who has gone to that particular you can say country, that is enemy property. You must have heard the term enemy aliens. Okay, enemy aliens means that those people who are not citizens of India and they are living outside India. Okay, and where they are living, these countries are not having good or the cordial relations with India. In such case, we call them enemy aliens. This is the broader, you can say, definition I'm talking about. Now here, enemy property means that those people who has migrated to China or Pakistan after the wars of 1962 or 1965, okay, or you can say even 1971 as well. So those people whose property was left behind, such property is called as enemy property. Okay, now let's talk about this particular act. Why this act came into picture was, as I told you, there was this wars in 1962, 1965. After these wars, we knew that there are many people who has migrated to Pakistan, and there are various property which they have actually left behind. In that case, in 1966, there were these talks which has happened in Tashkent. In, you can say, the conclusion of those talks was that in the conclusion of that particular talks, we have came up with this Enemy Property Act to dispose of the property. Okay, now coming to the discussion over here, let's see. Enactment of the Enemy Property Act 1968, enacted in 1968 after the India-Pakistan War of 1965. Okay, aimed at regulating properties of individuals classified as enemy subjects or enemy aliens. Now these people who has actually left and went to Pakistan, now we have classified them as enemy subjects and enemy aliens. Now initially enforced under the Defence of India Rules 1962. Initially such rules were there, or such provisions were there in Defence of India Rules 1962, because in 1962 also there was this war. Okay, so that was this thing. After that, definition of the enemy property. Okay, let's see. Refer to the properties left behind by the individuals migrating to Pakistan or China during the 1965 war or 1971 war. Okay, India-Pakistan wars and 1962 Sino-Indian war. You know that in 62 we had a war with you can say China, and in 65 we had a war with Pakistan. Then custodian of the enemy property for India. Now this is the body, custodian of enemy property in India or for India, that is under Ministry of Home Affairs. Now whatever property is there, this particular body will be taking care of that particular property. Okay, now there is this custodian of enemy property, and they will be taking care of the pool of the enemy property which is there. Okay, now moving further, here you will be seeing Tashkent Declaration and subsequent actions. So we had a war in 1962 with China, we had a war with Pakistan in 1965, and then in 1966 there was this talks, that was Tashkent Declaration between India and Pakistan, included discussion on the enemy properties as well. Okay, Pakistan disposed of the enemy properties in 1971. In 1971 they disposed of the property. Whatever they wanted to do with the property they did. Okay, but when we talk about India, we actually has hold these properties under the custodian as per 1968 Act. Okay, so after this declaration we went for an act. Okay, we appointed a custodian, and that custodian took care of the property. Now the property, 2016 there was this amendment, or you can say a bill was proposed in the, you can say, parliament. Why? Because before that there was various cases in 2005, 2004, 5 there was this case under in front of Supreme Court, wherein a person, let's say a person P, who has migrated to Pakistan after that particular war. Okay, but this person's son has stayed over here. Since there was this property was in the name of Mr. P, and Mr. P has actually gone to Pakistan, so technically now this is an enemy property. Okay, but this person's son is there. Now the son has claimed over this property because he is the legal heir. He has said that my father's property is now my property. Okay, how can you say that this is an enemy property? Okay, and Supreme Court has given a verdict in the favor of the son, and they have said that since there is a legal heir over here, and that is why this property is not an enemy property, this will be given to the son. Now after this case there are various people who has come and started to claim their properties. Okay, to avoid that, so they have come up with a change, and they have actually brought this amendment. Here you will be seeing passed in 2017 to amend the 1968 Act and the Public Premises Eviction of the Unauthorized Occupants Act 1971. This is altogether a different you can say act, but has something to do with this particular issue. Now expanded the definition to include the legal heirs regardless of their nationality as enemy subjects. Now they have, in this particular act, they have considered that even if there is a person who is P, he has migrated to Pakistan, now he is also having a legal heir, that is Mr. S, but the thing is he will also be considered, you can say, as enemy subject. Okay, for this act. Now we are not saying that this will be the, or you can say let's say there is this person, you can say Parvez Musharraf, and he has a son. Okay, but that does not mean, despite of his nationality, whether he is Indian or Pakistani or somewhere else, despite all these things, he will be considered as an enemy subject for this particular act. Okay, so he will not be given the property. That enemy property will still remain enemy property, and hence it will remain in the custodianship of the government. Okay, so it ensures that enemy property remains with the government even if the enemy's status changes. Okay, now that again I'm telling you that for the purpose of this bill, they have made sure that any legal heir will also not get the property, because in that case also it will be enemy subject, and considering that property will be enemy property. Okay, I hope that is clear. Now we will look at certain you can say cases wherein we will try to resolve this confusion which was created in 2017 Act. 2005, as I told you, there was this case which was there in front of the Supreme Court, Union of India versus Raja Muhammad Amir Muhammad Khan case. Okay, now Raja Muhammad, after migrating to Pakistan, had his estate declared enemy property. Now there was this person Raja Muhammad, he had this estate, and this estate was declared as enemy property. That was there in the 1968 Act, that if someone is migrated to Pakistan, his property will be considered as the enemy property. The Supreme Court ruled in the favor of his Indian son. His son did not go to Pakistan, his son stayed in India, and then he claimed that particular property. He said that no doubt the property was in the name of my father, but I am the legal heir. Now since my father is not here anymore, now this should be given to me. Okay, so Supreme Court has given this particular property to the son, okay, allowing him to reclaim the property as legal heir. Okay, moving further, they came up with the 2017 Act, wherein they made some changes. Okay, after that also there was some case in 2024 which was there. So here you can say Lucknow Nagar Nigam versus Kohli brother color lab case. Now Supreme Court ruled that the enemy property vested in the custodian is temporary. Now we are saying that when enemy property is there and we are taking care of this particular property by the help of the custodian for the enemy property, which is there under the Ministry of Home Affairs. Now that custodian, the term custodian itself is saying that he is just a custodian, not an owner of that particular property. And since he is not an owner of the property, we have to define that who will be the owner. So ultimately, with the rule of succession, etc., the owner will be someone else afterwards. But the thing is, the government is acting as a custodian only. Okay, so we are saying that no transfer of ownership from the original owner to the government or the custodian occurs. When you are saying that Raja Muhammad went to Pakistan, he did not change the ownership of the, you can say, that particular property. That property, by the virtue of Act, that is 1968, it went to the custodian, and the owner is still Raja Muhammad. And once Raja Muhammad is dead, after that there will be legal heirs of that property, they can claim the property. Okay, so in 2024 also Supreme Court has given this particular verdict that is just a custodian, that is not a transfer of the ownership. Okay, so that is the current position as of now. Now moving further to the next thing, which is the constitutional amendment in India. As I told you, there are various discourses which are there that whether it is so easy to change the constitution of our country. So when we talk about the constitution, you know that our constitution has various features. Okay, so our constitution is rigid as well as flexible. Why is that? It is because there are certain provisions which are very difficult to change. Okay, when we talk about the fundamental rights, when we talk about the federal structure of the country, so all these things are very rigid to change, and that is why there is a difficult procedure which has to be followed, and that is why we say that it is rigid. Okay, in USA also we will say that constitution is rigid because changing the constitution takes a lot of effort. Okay, second thing is it is flexible. Now there are certain areas like changing the name of the state. There are certain areas with respect to the citizenship norm, etc. These can be changed with a simple majority, and that is why we are saying that it is flexible as well. Okay, when we talk about UK's constitution, you will say that UK's constitution is not a written constitution, and that is why making a change in UK's constitution is very easy. Similarly, in India also there are certain provisions which can be changed with a simple majority of present and voting. Okay, that is why we are saying that it is also flexible, but it is also rigid. So that is why there are certain things you can change, there are certain things you cannot change. Okay, how will you define these things? That depends on the basic structure doctrine. You know that there are certain basic structure. After the Keshavanand Bharati, Supreme Court has made this doctrine, the doctrine of basic structure. Now when we are talking about this basic structure, this is something you do not want to change in the constitution. This is something which is fundamental to the constitution. Okay, so these are certain things which we will be discussing in our further discussion over here. So let's see. When we talk about the constitutional amendment, that means that we are trying to make a change in the constitution which is existing. Okay, how will you do that? We have article 368 in our constitution that talks about the constitutional amendments. Okay, let's see. A constitutional amendment refers to the process of modifying the nation's fundamental law, that is constitution, and article 368 grants parliament the power to amend the constitution. The amendment procedure for India's constitution balance flexibility as well as the rigidity, as I told you, which we have already discussed, that there are certain provisions which can be amended easily. There are certain provisions which takes a lot of effort to amend. Okay, and that is why when we are talking about the rigidity, there comes the special majority. There are certain, you can say, chapters in the constitution, or the certain, you can say, provisions in the constitution which require special majority. There are certain which requires special majority plus 50% of the ratification of the states. Now that will be difficult to achieve. Okay, then there are certain which are being amended with the simple majority, and that is why we are saying that that is flexible as well as rigid. Now it allows for the adaptability while protecting the core principle of the constitution. Why it is necessary for a constitution to be flexible? Why? Because with the time society changes, and when society changes, there is a need that these you can say legal provisions that should also be changed with the time. Okay, so that is the thing for which you can say that our constitution should be document which is organic. Okay, or you can say a living document that can be changed as per the requirement of the society. So that is one thing. Now why is that you require the constitution to be rigid? That is to make sure that government do not go beyond their limit of powers. Okay, when we talk about the absolute power, so absolute power has the ability to corrupt a person. Okay, so in that regard, it is made sure that there are certain core principles that should not be changed. Okay, so these core principles are basically, right now we call them basic structure of the constitution. Okay, now Keshwanand Bharti case 1973, the Supreme Court ruled that amendments cannot alter the basic structure of the constitution, and here Supreme Court has given herself the authority that they will decide the basic structure. Okay, because who will interpret the constitution? Supreme Court, and that is why Supreme Court will tell you that this is basic structure and this is not. So most of the time you will be seeing that fundamental rights can be amended, but they cannot be amended in a you can say way that it changes the basic structure. Okay, you cannot actually change the secular fabric of the constitution. You cannot you can say change the federal structure of the constitution. You cannot change the parliamentary form of the constitution, of the government in the constitution. So all these things are basic structure. Independence of the judiciary, that is basic structure. You cannot change that. Okay, so now moving further, ways to amend the constitution. There are three ways in which constitution can be amended. One is the flexible one, that is with respect to the simple majority of the parliament. Okay, simple majority means that 50% of the members who is present and voting. Okay, so that is there for the simplest form of, you can say, change which you can do in the constitution. Now where you can do such changes, there are these methods are applying to various provisions, and these provisions are like article 2, that admission or the establishment of the new state, 5th schedule, that is related to your tribal schedule and scheduled areas and the tribal areas, and citizenship laws, election to the parliament and the state legislature. These are certain things which can be changed with the simple majority. Moving further, you will be seeing that by special majority of the parliament, article 368, which is talking about a majority of the total membership of each house and 2/3 of the member present and voting. Total membership, when we talk about the total membership, 1/2, or you can say 50% of the total membership of a house. Okay, along with that you will need you will be needing 2/3 of the members which is present and voting. Okay, so don't you think that it will be difficult to attach 50% of the total membership, and then who are present and voting, they should have at least 2/3, or you can say 75% of that. Okay, sorry, that is 66.66%. so that is there. Now this is something which is to be attached, or when we are talking about, there are certain areas which are related to the you can say fundamental rights, DPSPs, fundamental duties, etc. In such cases, such majority will be required. Again, I'm telling you, when we talk about the special majority, that means that under Article 368, special majority means that 50% of the total membership of the house plus 2/3 of the present and voting. Okay, so that is one thing. Now coming to the third one, the third way wherein you are talking about the change in the federal structure. If there is a federal provision and we are trying to make a change in that case you will require the ratification of the 50% of the states as well. Why? Because when we talk about the, you can say, the federal features of the you can say constitution, that means that states are also getting affected over there, and that is why you would require that kind of majority. Here you will be seeing by special majority of parliament and the state ratification, a special majority of parliament which we have seen, that is half of total membership plus 2/3 of present and voting. Along with that you would require 50% of the state's ratification. That means that the state legislature will also decide on that particular bill by a simple majority. Okay, so in the state legislature or the state assemblies, that bill will go and they will have to, you know, pass that particular bill by the, you can say, simple majority. Okay, now where you can actually imply this particular method, here you will be seeing where federal structure of the constitution is being changed. Election of the president, because in the election of president you know that along with the elected MPs, MLAs also participate. Okay, so in that case election of the president is one such area. 7th schedule list, this is the, you can say a list which is talking about the different sphere wherein states, union can make laws. Okay, union government and state can make laws. You know that there are 3 lists. One is union list, second is state list, and third is your concurrent list. So you know that in union list only center can make the laws, in state list only state can make the laws, in concurrent list state and center both can make the laws. Okay, so that is their representation of the states in the parliament, Article 368 itself. If you want to change the procedure to change the constitution, in that case also you need to require you need to have a, you can say, ratification by the states. Okay, so I hope that is clear. These are the way you can change the constitution. Okay, so we can say that it is not very easy to change the constitution. It is not very easy to change the, you can say, basic principles in the constitution. Okay, I hope that is clear. Even if you are going to do that, after that there is Supreme Court to scrutinize that particular constitutional amendment. Okay, so it is not very easy to change the constitution in India. Okay, now what is the procedure? The procedure is, first you have to introduce a bill like any other bill. This bill can be introduced in either of the houses by both kind of member, one either private member or a minister. Okay, any member can actually go for the presentation or the introduction of that particular bill. Okay, after the bill is presented, okay, you don't require any prior you can say permission from the president as well. In such case, passing the bill, now after that there will be general discussion, etc. All these things are there in the parliamentary process. Then you have to pass the bill. When you are talking about the passing the bill, so you know that with respective majority, depending on the kind of bill it is, on the basis of which either simple majority or special majority. Okay, if you are having any amendment with respect to the federal features, then you have to go for the ratification as well. Okay, that is there. Now if Lok Sabha and Rajya Sabha are not agreeing on one thing, or you can say that particular bill, or you can say any changes over there, in that case there will not be any joint sitting. Okay, so in the constitutional amendment bills, you have to have passage of the bill separately from both the houses. Okay, so there is no provision of the joint sitting. Then moving further, presidential assent, if we talk about, after the passage of the bill from the both houses, then you have to send the bill for the president's assent, and president has to give the assent over here. Okay, so here after passage, the president must give the assent to the bill without power to withhold or return it. President cannot return it for the reconsideration as well. Okay, now coming to the last part, that is Constitutional Amendment Act. Once presidential assent is given, then the bill will become an act. This is the procedure how you change the constitution. Okay, now moving further to the next topic, this is talking about the Election Commission of India with respect to the assembly election in Haryana, with respect to the assembly election in the Union Territory of Jammu and Kashmir. We'll be talking about this. Election Commission was in news, so that would be important for you to know about the Election Commission. Now Election Commission is a body which is a constitutional body, because we know that there is this article 324 which is talking about the election commission. Okay, other than that, they are there are certain provisions which are given in the constitution, so we can say that it is a constitutional body. Second thing is it is an independent body. Okay, it is an independent and it is a permanent body. Okay, so there are certain features. We will be talking about the Election Commission of India, appointment, removal, etc., etc. Okay, so Election Commission of India is a permanent independent body established by the Constitution of India under Article 324 to ensure free and fair elections in the country. So since we are talking about Election Commission, that means that the idea behind is to supervise and control, monitor, supervise and control the, you can say, elections in India. Now, Constitution based Election Commission of India with powers of superintendence, direction and control of the elections. Okay, now what kind of election of Commission of India will hold? That is, one, parliamentary elections of the both houses, be it Lok Sabha or Rajya Sabha. Then state assembly elections, state legislatures. Here you will be seeing that where you have state legislative assemblies, there they will oversee the election procedure. Other than that, if we talk about the legislative councils, if a state has the second house, their election will also be, you can say, overseen by the Election Commission of India. Then elections of President of India and Vice President of India, these are also being overseen by the Election Commission. Now when we talk about the elections like you can say Panchayat and municipalities, you know that we have a 3-tier government. Okay, the third tier being the local bodies. So when we talk about the local bodies, the Election Commission of India is not responsible for their election, because for their election we have provision for the State Election Commission. Okay, so please note that they are not concerned with the local body elections. For the local body elections we have State Election Commission. Okay, moving further, composition of the Election Commission of India. For that there is this act. When we talk about the constitution is talking about limited things, then parliament come up with the act. Okay, so the act is Election Commission, condition of service and service of election commissioners and transaction of business act 1991. Okay, here you will be seeing it consists of the chief election commissioner and number of election commissioners as the president decide, or president may fix time to time. When we talk about the chief election commissioner, if there is CEC, then there is no need to be a chairperson of the election commission. Okay, but if along with the chief election commissioner there are other election commissioners, okay, so in that case CEC will be the chairperson. Okay, so that is there. Who will decide that whether ECs will be there or not? That will be decided by the president. Okay, now right now if we talk about, we have CEC plus 2 election commissioners. Okay, please remember that. Moving further, term of the ECI if we talk about, so here you can say that the term is of 6 years or 65 years, age of 65 years. Okay, whichever is earlier, that is the term of, you can say, member of Election Commission of India. Now resignation, who will you give resignation to? Obviously you will be giving resignation to the President of India. Okay, so that is about certain things. Moving further, you will be seeing the appointment of the Election Commission of India, or the members of the Election Commission of India. Okay, now chief election commissioner and the election commissioner will be appointed by whom? President. And similarly resignation will also be given to the president. Okay, on the recommendation of a selection committee. Now selection committee, there will be a selection committee of 3 members. Earlier that used to be done by the, you can say, recommendation of the union minister to the president, and president used to appoint the Election Commission of India or the members of the Election Commission of India. Then after that there was the Supreme Court's involvement. Then Supreme Court has actually created a select committee wherein there was a presence of the CGI as well. After that in 2023 they have come up with the act, Chief Election Commissioner and other election commissioners appointment, condition of service and term of office act, that is 2023. With that they have actually made a selection committee, that is Prime Minister of India, a union minister nominated by the Prime Minister, and the leader of opposition in Lok Sabha. Okay, so these 3 people will be there in the selection committee. Then there will be a search committee as well. Search committee head by the cabinet secretary. He will, or that particular committee will suggest a name of 5 people, and among them they will decide for the, you can say, name for the election commissioners. But the thing is, that is, they are not bound by these 5 names. They can also go for the other names as well. Okay, so that is the appointment procedure. What will happen is that there is a search committee. They will give you a name of 5 people. Along with these 5 people, there are other names which can also be used by this selection committee. Now this selection committee will decide on the, you can say, appointment, that is Prime Minister, Union Minister nominated by the Prime Minister, and the leader of opposition in Lok Sabha. These 3 people will decide and send these names to the President, and President will appoint the Chief Election Commissioner, and then on the advice there will be election commissioner as well. Okay, so I hope that is clear. That is the appointment procedure. Now moving further, we will be seeing the removal procedure. Talking about the chief election commissioner removal procedure, that is similar to the judge of the Supreme Court. Okay, there are two criteria on which a judge of Supreme Court can be actually removed, that is misbehavior. Second is incapacity. On similar grounds, the chief election commissioner can also be removed. Okay, and who will remove? President will remove, but there is a process. Okay, so here you can see he or she can be removed by the president on the basis of a resolution passed to that effect by both the houses of parliament. Parliament has to pass a resolution in that regard. Okay, and then president can remove that. And on the basis of what they can go for the resolution, these are the two: misbehavior and the incapacity. On basis of these things, they have to scrutinize and then pass a resolution for the removal, and then president will go for the removal. Okay, so that is the thing. Now talking about the removal of the election commissioners, we have talked about the chief election commissioner. Now election commissioners, if we talk about, so what will happen is that on the advice of the chief election commissioner, that can be removed by the president. Any other election commissioner or regional commissioners is removed from the office on the recommendation of the chief election commissioner. Okay, I hope that is clear. Now how can you differentiate over here? We can say that there is a, you can say, security. Additional security has been provided by the constitution to the chief election commissioner. Such security is not there with the case of the election commissioner and the regional commissioners. Okay, so I hope that is clear. Now we can move to the next part, that is your Goods and Services Tax Council, GST Council. Recently they had a meeting, so we'll be talking about that. Here you can see Goods and Service Tax Council, that is given under Article 279A. Here the suffix A means that was added later, and the constitutional amendment, that is 101, or you can say 101st Constitution Amendment 2016 was the amendment through which the GST regime has started. Goods and Service Tax, which has started in 2016. Now to oversee the working and the implementation of that particular tax regime, we had a GST Council. Okay, here you will be seeing that it is set up under the Article 279A of the Constitution as a joint forum for center and states. Now in GST, you will have representations of the states as well as of the center. Okay, it will have a stake, that is 2/3. It will have 1/3. Center will have 1/3. Okay, we'll be talking about that later. The GST Council is responsible for the recommending the matters related to the goods and services tax to the union and the state governments. Okay, objectives: the smooth implementation of GST, harmonization of the tax laws, whatever tax laws are there in India, and along with that the global standards, they will try to come up with such provisions, and then monitoring the taxation in India. These are the objectives of GST Council. Okay, now composition of GST Council, if we see, so council is made up of certain members, and there will be a chairperson. That chairperson is basically your Union Finance Minister. Okay, right now that is Nirmala Sitharaman. Now when we talk about the members, so Union Minister of States of Finance and Revenue. Second thing is one minister in charge of finance or taxation from each state. Okay, so basically from each state, whoever is taking care of the finance and the, you can say, revenue or the taxations, he will be in the GST Council, and from the Union Minister of State for the finance and revenue, they will be in the GST Council, and obviously Union Finance Minister will be there, and he or she will be presiding, or they will be the chairperson. Okay, now there will be a vice chairperson as well. Okay, among the members itself, they will choose a vice, you can say, chairperson elected by the council among the members. Okay, that is given under the Article 279A subclause 3. Now function of the GST Council. Functioning of the GST Council, when we talk about, so for the functioning there should be a quorum. Okay, quorum is the half or the membership must be present. Okay, so we have seen that there are, you can say, ministers from states, then we have a union minister of states for finance and revenue. Okay, and along with that we have a Union Finance Minister. Okay, so this is the basically, you can say, the composition, and among all these members 50% should be present for the quorum to complete. Okay, so that is one thing. When comes to the decision making, so here you will be seeing it requires 3/4 of the majority of the weighted votes. 3/4 of the weighted votes. Now why it is weighted votes? Because the weightage is different for center and different for the states. Here you can see the weightage for the central government is 1/3 and for the state government it is 2/3, which we have already seen. Okay, so that is about the GST Council and the functioning of the GST Council, which you can remember. Now last is the joint declaration of amphibious operations. When we talk about the joint declaration of the amphibious operation, that is a document which has been actually, you can say, put forward in the public discourse by the CDS itself. Okay, that is not important what is given in the document. What is important is that we have a document that is talking about the amphibious operations. Earlier there was another document, joint declaration, that was on the cyber space. Okay, now amphibious operations, what are these amphibious operations? So let's say Indian Army has to go for an attack on a hostile shore, or you can say hostile port. Okay, port of a country or the enemy country, we have to go for an attack. Now the thing is, you have to go for a port, then you have to take help of the navy as well. Okay, so here military is going for the, army is going for the attack and navy is supporting them. That is, you are attacking from the you can say land as well as using the services of the, you can say, navy. That means that you are going for the amphibious operation. Amphibious means both of them are involved in that. Okay, so for that you have this joint declaration. Let's talk about that. Chief of Defense Staff recently released the joint declaration for the amphibious operation during the Chief of Staff Committee meeting which was there. Okay, now serve as a guide for the commanders in the conducting amphibious operations. Amphibious operations involve landing forces on hostile shores via naval support. We are sending forces on the hostile shore or the enemy ports, etc., via naval support. Okay, now enhances the armed force ability to conduct diverse operations in the Indian Ocean region during both wartime and peacetime. Now why this is important? Because most of the time you must have heard that India is the first responder in the Indian Ocean region. Okay, so that is why India is taking the responsibility. Now that is why we have to be proactive. Then a vital element of multi-domain warfare reflecting is integration among the armed forces, and so that we can work efficiently, smoothly. These things are quite important for the amphibious operations. Now since we are talking about the CDS, I will tell you 2 or 3 facts about the CDS, so that if they are asked in the examination, you can be aware of that. So recommendation, when we are talking about the post of the CDS, that was recommended in 2001 by the group of ministers based on the Kargil Review Committee report that is given in 1999. Okay, on the basis of that Kargil Review Committee report, we have come up with the post of, you can say, Chief of Defense Staff. Now in 2002, the Integrated Defense Staff was created to eventually serve as the CDS Secretariat. Now Naresh Chandra Committee, 2012, remember this name? Naresh Chandra Committee in 2012 suggested a permanent chairman of the Chiefs of Staff Committees as a temporary solution. Okay, at that point of time they have actually suggested you can say a permanent chairman of the Chief of Staff Committees. Now the post of CDS was finally created in 2019 following the recommendations from a committee that was led by the Lieutenant General D.B. Ṭhekkar. Okay, so when we are talking about this particular name, that is Lieutenant General D.B. Ṭhekkar, so basically on the basis of the recommendation of you can say this particular committee, they have created the post of CDS in 2019. First CDS, you know that General Bipin Rawat was appointed as the first CDS. CDS who will ensure, it is CDS will ensure the jointness in training, logistics and the procurement of the 3 services. So basically what we are doing here is that we are trying to integrate the services so that there can be communication, so that, you know, in the case of, or you can say in the need of hour, all the 3 services can actually you can say perform efficiently with each other. Second thing is that would be a better management of the resources that will also be happening over here with the help of the CDS. Okay, I hope that is clear. So we have discussed almost everything with respect to this particular week. Now there is a small test. There are 5 questions for you. You have to read the questions and answer to me in the comment box. Okay, the 1966 Tashkent Declaration involved discussion about the enemy property between which 2 countries? India China, India Pakistan, India Bangladesh, India Sri Lanka. So you can answer me. Question number 2. Which article of the Indian Constitution provides the procedure for amending the Constitution? 368, 370, 356, 368A. Okay. Question number 3. Who appoints the Chief Election Commissioner of India, the President of India, the Prime Minister of India, Chief Justice of India, and the Union Cabinet? Okay. It is a very simple question. Question number 4. Under which article of the Indian Constitution was the GST Council formed? Article 246A, 269A, 279A, or 280. Okay. Now the last one, that is, which committee recommended the creation of the CDS post in 1999? Naresh Chandra Committee, Kargil Review Committee, Saketkar Committee, and the group of ministers. Okay, so you have to attempt all these questions. Answer to me in the comment box. With that, I would like to take your leave. If you have not subscribed the channel, please subscribe it. Have a nice day. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.